May it please the Court, my name is Patty Andrews and I represent the defendant, PepsiCo, referred to today as the company. A complaint against PepsiCo was filed on April 28th and was received by PepsiCo's agent of process in North Carolina. However, the agent did not provide the company with the notice until approximately September 18th. Once received, unaware that a lag time of almost 5 months had already occurred, the service was set aside unopened by a company employee for almost 3 weeks. The company's in-house attorney received the service on October 5th, at which time a default judgment had already been entered against PepsiCo. As stated in the motion of September 13th, PepsiCo has moved for the court to grant relief. Under Federal Procedure Rule 55C, the company's motion asks the court to set aside for good cause the default judgment in its entirety. As we are reminded in Pelican Products Corp., cited in the motion, the company respectfully recognizes that under Federal Civil Procedure Rule 60B1, it is within the domain of the court's discretion to set aside the default judgment, and PepsiCo prays for relief from the court to be permitted to resolve the case based on its merits. Rule 60B1 permits relief from a default judgment for inadvertence on a motion made within 1 year of the judgment. This rule is construed liberally by the courts to ensure that doubtful cases are resolved on their merits. Hibernian National Bank, cited in the motion, provided 3 factors the court may consider to determine whether sufficient grounds exist for setting aside a default judgment under Rule 60B1, which are the extent of prejudice to the plaintiff, the merits of the defendant's asserted defense, and the culpability of the defendant's conduct. Here the company believes that setting aside the default judgment will not result in undue prejudice to the plaintiff. The defense of the company will assert is reasonable and persuasive, and the culpability of the company's conduct is minimal, both in its actions and in comparison to the merits of its defense and the judgment against it. The facts of the motion are as follows. The plaintiff filed its complaint on April 28th, then provided proper service to PepsiCo's agent of service. Service was properly served on the company's agent. The agent failed in its duty to its client, PepsiCo, to deliver the service in a timely manner and did not provide the service to the company until September 18th, which under Rule 12A1AII, this was long past the 60 days set for the company's answer to the complaint. This would constitute neglect, but it was not PepsiCo's neglect. The company's conduct is not culpable because it did not intend to thwart judicial proceedings, nor did the company recklessly disregard the effect of its conduct on the proceedings. Unfortunately, as a large organization that produces numerous consumer products, PepsiCo is, with some regularity, the subject of litigation. And unlike in Rogers v. Hartford Life, cited in the motion, the company has established minimum internal procedures for timely response to litigation. However, because of the inadvertent delay in receiving the summons, by the time the company's lawyer became aware of the suit, the deadline for an answer had already passed. But for the agent's neglect, PepsiCo would have acted to answer the complaint properly and defend itself. The company has a meritorious defense against the allegations, and the court's decision to hear the case will not prejudice the plaintiff because it is the same defense the company would have brought had it timely responded to the complaint. Notwithstanding the obvious harm the company will suffer from the default judgment, conversely, the company's defense strategy has not benefited by the delay in its appearance before the court in response to the complaint. In its defense, the company will produce evidence that its product, Aquafina, was developed outside of any discussion the plaintiff claims to have held with the company 28 years ago. The company believes that the plaintiff's claim for damages is conflated on assumptions and not based on any actual evidence of revenue recognition by the company. And if damages were proved by the plaintiff, they would not amount to $1.28 billion. For these reasons, in order for justice to be served, we pray that the court will grant relief by setting aside this default judgment and permitting the case to be heard on its merits. Thank you, Your Honor.